This is a damaging blow for the Met Police and a win for freedom of expression. If you would like to read the full judgment, a link will be in the description. In the High Court of Justice, Queen's Bench Division, Divisional Court, the 3rd of November 2022. In March 2021, after the victim went missing while walking home in South London, her remains were found and a serving police officer was charged with her kidnap and murder. The claimants, members of an informal collective who proposed to hold a public vigil in memory of the victim, advertised the event and large numbers showed an interest in attending. However, in statements at meetings, in letters, and in a press statement, the defendant police commissioner categorized the proposed vigil as unlawful on the basis that it contravened the restrictions on gatherings which were then in place for the protection of public health during the COVID-19 pandemic. At the material time, the relevant restrictions were contained in the Health Protection, Coronavirus, Restrictions, All Tiers, Regulations 2020, Paragraph 5 of Schedule 3A, to which restricted the holding of a gathering of more than 30 persons in a public outdoor place in a Tier 4 area such as London. Part 3 of the regulations, dealing with enforcement, made it a crime to contravene those restrictions without a reasonable excuse and gave the police power to arrest and/or serve a fixed penalty notice, FPN, imposing a fine of £10,000 on someone they reasonably suspected of committing such an offence. In the event the claimants abandoned their plans for the vigil, they sought judicial review challenging the Commissioner's decisions relating to the vigil on the grounds that the Commissioner had ignored the possibility that the rights to freedom of expression and freedom of assembly under Articles 10 and 11 of the Convention for the Protection of Human Rights and Fundamental Freedoms might have supplied a reasonable excuse for contravening the restrictions on that occasion, and 2. Failed to conduct the fact-specific proportionality assessment, which the police were duty-bound to conduct in order to reach a decision on that point. On the claim held, claim allowed. 1. A person who participated in or held or was involved in holding a gathering in contravention of the restriction in Paragraph 5 of Schedule 3A to the Health Protection, Coronavirus, Restrictions, All Tiers, Regulations 2020 would have a reasonable excuse, and so would not commit an offence, if their conduct was a lawful exercise of the rights protected by Articles 10 and 11 of the Human Rights Convention. Whether that was so would depend upon a proportionality assessment that took account of all relevant factors based on a fact-specific inquiry. As the burden of proving that there was no such lawful excuse lay on the prosecution, a lawful decision to prosecute or issue an FPN would require consideration of whether that burden could be discharged. No enforcement decision could lawfully be made without a proportionality assessment, and, as part of that exercise, the police had to make some assessment of the health risk and balance the seriousness of any such risk against the rights engaged. That duty had to be discharged when any form of enforcement was under consideration, and, in discharging it, the police had a public law duty to take reasonable steps to inform themselves about relevant considerations. Accordingly, they could not simply assume that any relevant gathering caught by the regulations would pose a serious risk to public health and were not entitled in law to ignore the question of what the available evidence might show about the gravity of current public health risks. 2. In the present case, each of the decisions complained of amounted to an interference with the claimant's convention rights, because each had had a chilling effect and made at least some material causal contribution to the claimant's ultimate decision to cancel the vigil. None of those decisions was in accordance with the regulations, properly interpreted, as they did not give proper effect to the reasonable excuse provision and failed to carry out a fact-specific proportionality assessment taking all relevant factors into account. Given that a proportionality assessment was a legal requirement, it had been incumbent on the police to engage with the organizers to see whether the event could go ahead in some appropriate form, taking into account whether adequate social distancing could be observed and maintained. They had erred in law in failing to engage properly with the claimants on the issue of appropriate measures to mitigate health risks of the public attending the proposed vigil and then to assess the residual risk taking such measures into account.